evening and welcome to the April 14th meeting of the Indian River County Planning and Zoning Commission. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next time I really like to read that. Okay, approval of the minutes. Have a motion? Okay, motion by Jen, second by George Hammer. All in favor say aye.
Aye.
Opposed? Motion carries. First item on the agenda is it's a consent. This is quasi-judicial if we take it off the consent agenda. It's Indian River Park of Commerce, request to modify the phasing schedule for the Indian River Park of Commerce located west of I-95 at the northwest corner of State Route 60 and 98th Avenue. Does anybody want to take this off the consent agenda?
Move approval as presented by staff.
Second.
Okay, all in favor say aye.
Aye.
Opposed? Motion carries. Next item on the agenda is Beach Cove. This is quasi-judicial. Darcy, would you? Well, first of all, I'll read it and then we'll swear everyone in. This is a request for preliminary plat and major site plan approval for Phase 2 of the Beach Cove Mobile Home Park, located on the north side of 99th Street, west of the FCC Railroad. Zoning classification is residential mobile home district up to 8 units per acre. Land designation is mobile home rental park up to 8 units per acre. The proposed density is 4.08 units per acre. Darcy, would you swear everybody in? Okay, Mr. McCoy.
Thank you, Chairman. This is an application for major site plan.
Is your mic on?
Yeah.
John?
Thank you.
Much better.
This is a major site plan and preliminary plat application for Beach Cove, which is a mobile home development. The subject site is located in the North County, just a little bit west of US 1 and adjacent to the city of Sebastian. The city is adjacent on the north and the west perimeters, and the county is adjacent on the east and the south perimeters. And the overhead shows the zoning in the county, which is RM6 to the bottom, industrial to the east, and A1 to the east. And then the zoning within the city of Sebastian is RS10. The next aerial shows the aerial. Next slide shows the aerial. And this shows the physical improvements that have been done to the park so far. This park was developed, to my understanding, in the 1970s. It has been upgraded quite a bit since I got here in the mid-80s. And you can see the existing mobile home development there. The remaining development would be sort of that northeast corner, and then the entire northwest area is where the proposed Phase 2 improvements are to go. Surrounding the site, you can see the railroad tracks to the east. Further to the east is US 1. To the north is presently a sand mine. To the west is part of the Sebastian Highlands, and between the subject site and the property to the west is a Sebastian drainage right-of-way. And I'll talk a little bit about that in a moment. Excuse me, this slide shows the overall design. And the site is just a little over 17 acres. It's got 129 proposed units. That's total, existing and proposed. And it yields a density of 4.08 in the overall. As far as the phasing goes, the phases are discontinuous. The green is what they're calling Phase 2A, which will be their first phase of construction. It includes a couple of scattered lots, 5 at the top, the recreation improvements in the northeast corner, the one scattered lot sort of in the west central, and then the retention area on the western perimeter. The orange is the proposed Phase 2B, which is completely residential. The gray area you see there is a potential future phase, and they have some work to do as far as flood zone work is potentially to get that future phase going. As far as traffic circulation, what I have in black there are the existing, or generally the existing roads. What is in brown is the proposed roads, and you'll see that loop is completed on the north, and then the two southern roads kind of loop at the end in dirt right now. As far as stormwater, now let me just go back to traffic for a second. They did a traffic impact analysis, and really the proposed units won't generate that much additional traffic, so there's no off-site improvements. And this is really at a dead end of 99th Street, so they access US 1 through 99th Street. So that's sort of the bigger picture as far as getting back out and getting on the network.
Is there a reason that the road called Professor Lane is not shown as an additional improvement there between the two Phase 2Bs squared? That's just an oversight, right?
That would be.
Okay. Thank you.
Right, and it, as you pointed out, it is Professor Lane, and they are Gilligan's Island themed roads. So yes, that was an oversight that connecting road between those two blocks wasn't shown. On the drainage plan, the retention is a single lake, and the stormwater is conveyed there by pipes, and it's piped to the stormwater treatment pond, treated, and then discharged. The stormwater treatment pond is located in essentially the lowest area of the site, which is the southwest corner. The proposal right now is for the pond to outfall to a drainage right-of-way on the west side, and then eventually work its way into the canal system within the city of Sebastian. As indicated in our conditions, and I've updated the condition, that the applicant will need to get approval through the city of Sebastian for this connection. If they don't, they'll need a redesign. We have been coordinating with the city of Sebastian throughout this process, and we had the applicant indicate that the city of Sebastian on their plans is a permitting agency, so the applicant was certainly aware of that as well. The next item I'd like to touch on are environmental aspects, and there is an existing just a little over 1 acre wetland right adjacent to the stormwater, and again it's in the southwest corner, which is the lowest portion of the site. The applicant's proposing not to have any impact on that, which is basically the preference from a regulatory standpoint. That gets us to the landscape, and I'm primarily just going to cover the buffering, and that's again where the area of development would be. For the west and the north, which is adjacent to single family, it's a type B buffer that's 40 feet wide, and from a buffering perspective, A is our most intense, C is our least intense. The type C buffer is also 40 feet wide, and it's required on the south, the east, the two east sides, and those need to be complete prior to certificate of completion. With that, I'd like to get to the staff's recommendation. Staff recommends that the Planning and Zoning Commission approve the major site plan preliminary plat for Beach Cove with the revised condition that prior to an LDP, the applicant needs to obtain that approval from the city of Sebastian or revise their design if they can't obtain that approval. And prior to completion, they need to construct all of the required buffers and sidewalks. Thank you.
Okay. Yeah, please go ahead, George.
John, on this drain, this storm water, which seems to be the biggest concern right now, the canal, I thought that canal drains south.
There isn't a canal there.
Where the water flow would be headed toward the south.
Let me just go
I thought
back.
Sebastian kind of came the same direction. Now, I understand they would put water in, which may get ahead of Sebastian's water and block it up, but
It will flow to
I understand how.
It will flow to the south once discharged.
Maybe they can explain their real concern, because, I mean, it looks to me like it's, well, kind of out of their way. It goes into the Sebastian drainage area, but it's going into the county portion south of Sebastian city limits, right?
It actually come down and it turns west into the city, actually. That canal is a right-of-way within the city of Sebastian, and I believe it connects to their Elkham Canal. So that water then
After it goes south, it turns west?
turns west.
Oh, okay. All right.
Is it proposed that there'll be more output into that canal than currently exists?
I would have to let the applicant's engineer address that as far as the pre-post and whether there's a greater volume or a greater rate.
Right.
Also, gentlemen, we have Rebecca Grohol here with the City of Sebastian. She's a growth management director for the City of Sebastian. And I have to divulge ex parte communications. I stopped in the City of Sebastian the other day, and Rebecca talked to me and said that they had a concern with this. I recommended that she come in to the meeting tonight and voice those concerns and answer any questions that you all have.
And Madam Chair, now that you've raised that question, it's probably a good time, if anybody else has had any ex parte communications or separate investigations, you should probably disclose them at this point.
Okay.
I have not.
Yeah, it's only Sebastian.
Whoa, get my ire up here. Okay. Does anybody have any further questions
just follow
of
up
staff?
one last thing.
Wait, I'm sorry.
Yep. Based on your ex parte communication, you probably should state for the record whether you still have an open mind and can base your decision on the evidence presented today.
Oh, no, I still have an open mind and can base my decision on the evidence today.
Thank you.
Does anybody have any questions of staff? Okay, would the applicant like to make a presentation?
Hi, my name is Pat Farland, and I'm with the engineering firm Culpeper and Turpinning. And we certainly agree with the staff recommendation. Regarding the drainage question that was asked, and I'm happy to answer anything else that any other concerns that you have, the pre-development versus post rates and timing or rates will be met. Only the southwest corner of the property drains that way. So we have sized the control structure so that only that pre-development volume goes out. So we didn't take credit for the whole property.
What type of event would hit your overflow to go out?
Well, during the wet season.
Well, I mean, you had to have, was it
Any event would.
A 10-year?
So because the system is set just like every other system to restore itself back to the control elevation to get ready for the next rainfall event. But it is, as I said, the historic flows have been modeled there, which does not include the whole property. It's only maybe a quarter of the property, a third of the property. And I will mention again, we have been in contact with the city since 2005. In 2008 was the time that I talked to them. The project went quiet for about a year because there was a problem with the county sewage system, which has been solved and resolved. And I have to tell you, I must have had a great dream one night because I woke up yesterday morning believing that I had this letter from the city in my file. And when I got the call from Mr. McCoy yesterday, I scrambled and started looking around, and I don't have the letter. So I guess I dreamed it. I thought I was done with the city, but we're happy to comply with all of those things. We have our water management district permit already, so I have all the calculations and everything that I'm sure they'll be looking for, and that's a condition of the final or the land development permit. So.
But just so I understand, you're not, the way it's designed, there will be no additional discharge of water into the canal than currently exists now in its unimproved state.
That's correct.
Okay.
Okay. So I'll just ask for your approval tonight. Thank you.
Mr. Furman, you had indicated that when you mentioned that the discharge from the western portion of this project goes into that stormwater retention, what is it, a dry retention or wet retention? I forget. Wet retention. Where does the drainage go for the rest of the project?
The whole project goes to that stormwater area. Historically, only the southwest part of the property went that way. So we modeled and have proposed a control structure that will still only let as much go out as historically did. So we're not taking credit for runoff from the entire property. We're only asking for credit from the historic runoff of that southwestern portion of the property.
to be added to what you had from the eastern side.
So the stormwater retention area and the control structure will contain the additional water and only let it go out as fast as it did
Okay.
prior to the development.
Okay, does anybody have any questions of the applicant?
I have a question for staff, if I can go back.
Thank you, Mr. Harlan.
The letter we received tonight in our packet from Mr. Minner, the city manager, seems to indicate that Sebastian has some pretty severe issues with this, and not the least of which apparently is a communication or a lack of communication. And my question is the verbiage that has been entered into the new page 4 that we got, the underlined verbiage, is that enough to address the concerns that we have in this letter?
Yeah, good evening. I'm Bob Keating, County Community Development Director. Rebecca can probably address that, but I talked to Al Minner yesterday on the phone, Al and Rebecca, and they said that on the phone, just like Al's letter says, they said they don't say in there that they oppose it, they don't say that they reject it. And we have coordinated with the city, and the applicant's been in touch with the city. I think right now there are still some unknowns on their part. They haven't done a detailed analysis of the engineering details, and at this point in the site plan process, we don't even require that. We'll require that at the land development permit stage, and that's when they can see the detailed engineerings, all the calculations, and make a decision. I think from the letter you'll see that the city seems to have two issues. One is the capacity of the system, whether or not the system can actually take if there is any additional inflow, whether or not it can actually accommodate that. The second is a financing issue. The city of Sebastian has a stormwater utility, which means the city actually has a non-ad valorem charge to every property owner in the city to actually cover the cost of stormwater management in the city. This property is not in the city, and it's using city drainage facilities. So the city, I think, has a reasonable concern regarding whether or not this property is paying its fair share. So I think the important part about Mr. Minner's letter is it doesn't reject out of hand the outfalling into their system. It keeps open that possibility, and it acknowledges the fact that even if they allow the project to outfall into their system, there could be some charges involved.
And in your opinion, the line that you have inserted into recommendation number 1, that one line that has been inserted, is enough to address the concerns of the Sebastian City right now?
Actually, our initial condition addressed their concerns. The addition really addresses our concerns. What the addition does is, the way we had it initially is, if the applicant doesn't get authorization from the city to outfall into the city system, they would have to redesign. And without that additional language, the plat would have to come back to the Planning and Zoning Commission for reconsideration. With the language that's in there now is they have to either get the city's authorization or they have to redesign it. So by having the option to redesign it, it can stay at the staff level.
Yeah,
so,
thank you.
Alan, is there any historic flow issues with this canal? I mean, have they got any rights to that canal at all, having been there as long as they have?
Has the applicant got rights to the use of that canal?
Yeah.
Well, I don't know much about the history of that particular canal, but I think up to some point, they probably do at the levels at which they've been using
They
it.
stay historic.
Yeah, if they stay at historic levels, they probably have some rights to continue to do that.
I mean, the reason is the condition about redesign, I was just looking at, if you redesign, where is he going to go? I don't know, I'm not an engineer, but I would just be, as having been there as long as it is, I would think they had some issue of rights, as long as they didn't know, succeed what they've been doing, but that'd be a legal question.
The county attorney is correct. Historic drainage has to be maintained for upstream and downstream owners. That's a state law. It's a state statute. And I don't want you to give you the impression that we've been hiding from the city. I had a pre-application with the city in 2002 with the city engineer who, the first statement on these notes, it was not me. The city of Sebastian was very receptive to the idea of providing positive legal alcohol for the project. It's only just so this project has been going since 2002. So it just dropped between the cracks in the last 2 years with this little sewer system headache. So we don't have any problems going to the city. There's correspondence. This is all correspondence to the city. We've been written letters and emails and...
What was the last correspondence, Mr. Farland?
My last discussion with the city was in 2008, where I talked to Mr. Stringer at the city, and he was to send me their agreement. And he did not, and I honestly dropped the ball. It's just, again, because the project went quiet. And I told you about my dream a few minutes ago. We have been, there's plenty of communication with the city. We're not hiding from it. It's just,
the proposal
and
is
it'll
pretty
be
clear
necessary
about
to come back for the final permits.
approval. So they can't sidestep Sebastian with what they've proposed. I mean, like John says, it's fine in that regard. I mean, they've got to get it done.
Yeah.
I'm sorry, I was jumping the gun. Were you finished, George?
I'm done.
Because I started to interrupt you, and I apologize. My concern is whether the change in the language meets approval for the city of Sebastian, because it seems like to save us all headache that I don't see any problem with this project as long as the city of Sebastian. So I think we really need to hear from them before, at least I do, before I can vote.
Thank you, Jens. That's a good idea. Ms. Gurhall?
Hi, good evening. Rebecca Grohall. I'm the Growth Management Director for the City of Sebastian, and we are fine with the language that county staff has put in there. We really wanted to just memorialize our concerns. I think you heard the engineer record just testify that this has slipped through the cracks a little bit. 2008, 2005, 2002, a lot of water has literally passed under the bridge and into the city's stormwater system. That is an area of concern for the city. We feel confident that we're going to take every effort, though, to work things out with the applicant and ensure a project that's going to benefit every party. So we just really want to make sure it does not slip through the cracks, though. Does that answer your question?
So, well, if we go ahead and prove this, you all aren't going to be mad at us. You feel like because of this wording, you can go ahead and work this out.
Definitely. We're never mad at the county. I think we have a really good working relationship with them through. It is the city stormwater system. We want to make certain that the city's needs, we're looking out for our taxpayers there, are covered.
So you're okay with the wording, and we can go ahead?
Yes, and we're certainly not here in opposition to the project. We just really want to make sure that this moves forward with the appropriate conditions.
Okay, thank you.
Thank you.
Mr. Farland, I have a question for you. Staff's condition here is that if the city of Sebastian and the project don't meet eye to eye, that you will have to redesign the system. Have you looked at that, and you have any idea if it's possible to do that? Would you have to go with a smaller number of lots?
It certainly is possible. I would say that certainly more stormwater area would be needed, so it would require a loss of lots, yes.
Would this come back, who would this come back before on the LDP?
Pardon me?
Will this come back before planning and zoning for the land development permit?
No, land development permit's a staff level approval.
Okay.
Yes.
All right, so we won't see this again.
A redesign comes back.
No, a redesign wouldn't if it's just a minor outfall issue.
I don't think that's, would you consider it minor?
I don't know if the city of Sebastian considers it minor.
I don't either.
It seems to me the city of Sebastian has a veto right here. If they don't get happy, they say no. This guy has a chance to redesign it, and then if the city of Sebastian is happy, then it's done.
Yeah.
If the city of Sebastian never gets happy, they can't go forward. So I think everyone's interests are protected. I don't think we're not making Sebastian walk the plank on this one. I don't think at all. But in fact, giving them all the power they need to make sure that their taxpayers are protected, which is sensible.
Okay.
I'd
You're
be
okay
happy
with
to
it?
make a motion if you're ready, Mr.
Please.
Since we've asked everybody's permission and it's been granted, I would move approval as submitted by staff.
I second it.
All in favor, say aye.
Aye.
That second was Todd Brecknana. Okay, Commissioners' Matters. Thank you very much. Any matters? Okay. Planning matters?
Thank you, Madam Chairman. I'm Roland DuBois, Chief of Environmental Planning and Code Enforcement. We have a staff update on David Damro's appeal, which was continued or tabled from the February 24th meeting. And I'd like to just give a brief summary of the information provided in my staff report on this matter. Just a brief refresher. This had to do with a non-conforming salvage yard at 4410 45th Street in Gifford. There was an issue on whether or not the use had ceased operation for a period of a year or more, and how that affected the non-conforming use. There was a lot of testimony and presentation at the February 24th meeting on all sides of the issue. Ultimately, the matter was tabled by the Commission on the issue of state licensing requirements, whether or not Mr. Damro and his business had such licenses, and how that affected the legality in determining whether or not his business was legal, how that affected the nonconformity cessation issue. So that was the main reason it was tabled, as you all may recall. There's a few issues I'd just like to briefly go over, but essentially, after considering the information that was presented at the February 24th meeting, doing further research into the licensing issue, also we got some case law from the Mr. Damro's attorneys. Considering all the factors, staff decided to withdraw its determination of cessation of nonconformity. So we're presenting this to you as an informational item. Since we've withdrawn that determination, the appeal's been resolved, and we're not asking for any action tonight. This is an update. Just briefly, and I'm just going to hit the main points, but essentially one of the key factors on the continuation of a nonconforming use, essentially 904.081, as I mentioned, says if a use ceases for 1 year or more, it ceases if it's a nonconforming use. A key word in that section, though, is cessation for a continuous period of 1 year. At the February 24th meeting, we gave evidence. We heard testimony actually from people who live next to the property, either day to day. And I think from staff perspective, it's clear that the daily operations of the salvage yard, all appearances, ceased several years ago. But the issue was continuation or continuous non-use. And at the meeting, Mr. Damro actually provided testimony under oath, provided receipts, that although that the use hadn't been occurring on a daily basis, it was periodically used. Therefore, there was no continuous period of a year that it did not occur. And based on that sworn testimony and evidence presented, from staff's perspective, the conclusion is, based on that testimony, we're not in a position to refute his information that it did not cease for a continuous period. So we accept that. On the other issue, on the state licensing requirement, we did substantial research since the February meeting. And if you recall, there was an adjacent salvage yard business owner who testified on the requirements of state licensing through the Department of Revenue, particularly focusing on what's called a second-hand dealers and secondary metals recyclers licenses. And at the time, we were not able to determine whether Mr. Damerow had either of those licenses. Since that time, we did research. We had to work through the Sheriff's Office to get information from the DOR on currently licensed second-hand dealers and secondary metal recyclers. What we did find was the other salvage yards on Gifford happen to have those licenses. We did not find one for this particular business. That being said, what we did detailed research in the Florida statutes. There's actually a provision where what's called a salvage motor vehicle dealer that's exempt from needing the second-hand dealer's license, and also under our salvage yard business county requirements, someone doesn't necessarily need to be a secondary metals recycler either. So in the end, we concluded if someone doesn't have a secondary metals recycler or second-hand dealer's license, it appeared in this case that he would at least need one of the three licenses that I mentioned. If not one of those two, then a salvage motor vehicle dealer. In the end, with our research, we couldn't find anything that said that this business, AAA Auto Salvage, had one of the three licenses. But nevertheless, which I'll now get into, we also receive case law from Mr. Damerow's attorneys on that issue of whether he has them or not. How does that affect this decision of cessation of the nonconformity? And the case law that was provided by the Mr. Damerow's attorneys since the last meeting are compelling on that point. And even though the cases that were presented and reviewed by county attorney staff are not necessarily Florida cases, they were specific to the point. And in the end, county staff, attorney staff concluded that yes, there is a separation here, and that the requirement of state licenses is not a decision or factors to this issue that we were presenting you on this cessation. And I think they just a quote from one of the case laws. Essentially, it was the failure to obtain a state license does not terminate a valid nonconforming use because the power to license is distinct from the power to zone. That's kind of the essence of the law. So in the end, we've accepted that legal determination or opinion, and therefore the issue of licensing, which even at this point we feel that there's some state licensing issues that Mr. Damerow does not have, it's moved to this point that was before you, which led to our withdrawal of our decision making. So let me just kind of summarize. Essentially, from the staff perspective and from actually those who came who lived next to the property, again, from all appearances, and we still are of the opinion that essentially the day-to-day operations did cease. They've ceased for several years. However, once you get down to the technical definition and regulations, the issue of continuous non-use, the evidence was that there was no evidence to refute that. And on the licensing, irrespective of whether he has those licenses, which it appears he doesn't have all of them, that is not a factor in the legal determination of whether the nonconformity had ceased. So based on those issues, we withdrew our determination. The one other point I want to make is, although we're withdrawing the issue of the cessation of the nonconforming salvage yard, there are other issues that we're still pursuing through code enforcement and through the health department. There are other issues that still pend related to health issues, pollutant discharge, building repairs without permits, things like that. So those are things that are happening separately through two different boards. But on this issue, we've withdrawn for the reasons I've explained.
Was there no Florida case law in point?
That's correct. In fact, I don't want you to be left with the impression that Mr. Damerow's attorney submitted some law. The law said you didn't need a license to impact this nonconformity issue, and that was the end of it. In fact, our staff started back on that issue from scratch, researched it from the beginning as well. In the end, came up with the exact same cases that they did. I think at this point, the vast majority of cases in America are pretty clear that this zoning question, this land use question is separate from the licensing question, unless the licensing statutes are themselves intertwined with the use of the land. And when you go to Chapter 538, which is the licensing statute we're talking about here, there is no connection whatsoever between those licensing statutes and the use of the land. So we independently reached the exact same conclusion.
Out of curiosity, Alan, can he start back into business without having licenses? I don't mean start back into business. Obviously, our point is that he's been in continuous business anyway. But can he continue on without having the licenses?
I think that there's a path to deal with that, which is going back to the licensing department or state agency and taking essentially filing a complaint saying someone's conducting this activity which requires a license, but this person doesn't have a license, and the state would look into that question, and the state could shut that operation down unless a license is obtained.
Oh, I know it has no impact on us. That was just a curiosity question.
It doesn't have an impact on us, but I think it really does in our ordinances, and it seems like to me where we have this problem, and it could come back, or a similar one, and as well with the ongoing violations from the EPA or DEP and our health department that have been continual and ongoing and are fairly serious. And when we talked about this last time, it came up that we were putting regulations that were stopping people from doing business. And it seems like to me that most businessmen are going to do the right thing. And if they aren't, when it's presented, then they will change their practices. That's just been my experience. But there are those who never will. They don't care. And when we have that continually confronting us, we need to be able to deal with it somehow. And it seems like maybe we need to rewrite the ordinance for nonconforming use that if violations continue and aren't dealt with, that should revoke the nonconforming use.
It seemed to me it was a very difficult burden to meet for the staff last meeting. Very difficult. Yeah,
that's an excellent point. And we've struggled with this with non-conforming uses before. I think y'all remember the source. I mean, we dealt with that for several years. I'd spent a couple more years in court. But the bar that we had to jump over was that we had to prove there was not a single transaction, not any type of business occurred on that site for a continuous period of 1 year. Now, I can tell you, when we looked at the aerials, it was obvious that all the cars were removed, except he might have missed, he might not have been good at removing all the cars, so he might have got the benefit of the doubt there. The other thing is, when he submitted the receipts to us, I think staff thought that they were suspect. Most of the receipts, they were not consecutively numbered. They didn't have a name of a business on there. There wasn't sales tax shown on them. I mean, to us, let me just leave it. We felt they were suspect. But we really didn't have a basis to say he didn't do it, he didn't have any transaction, those receipts are false. But we came to you with the evidence that we had. I think, in retrospect, I wish we didn't come to you because the evidence that we had didn't look good under cross-examination, and the next time we're going to look a lot closer. But I can tell you, it's a tough bar to reach with the termination of nonconformity for cessation of the use.
For cessation of use, but where you have ongoing violations in other areas on that same piece of property that are not being addressed, and the fines are mounting, and the problem continues, and especially if it's a pollution problem, I think we need to be able to address that somehow. And I know it's not necessarily our
I was going to say, Lindsay, I appreciate where you're coming from, but this body really does deal with rules and the zoning and the land use issues. And I was going to ask Alan, in intertwining all of this into a land use rule, is that, I mean, when you said that you hadn't seen it, do you see something like that that would allow this body to do something like Jen said, or is that just that much more complicated with the rule of law? I mean, if the county adopted this and said you get violations, Department of Health violations, 3 of them, and your nonconformity is lost. I mean, it seems to me the farther you go down that track, actually, Jen, the more complicated it may get.
Well, I think it gets complicated, but I do think it's a path that's available to you. But again, it's a black to gray to white issue. Where is the intertwining enough? Where does it stop being enough? Very difficult questions
I see.
to answer.
But I mean, we could put them into land use regulations if we wanted to. I mean,
you could, for example, come back to, in this case, you're talking about a discontinuance of a nonconformity. You could go back and ask the county commission to amend that ordinance to essentially say, a use of the property in violation of state law, which, again, I don't know how we'd say it, but intertwines with land use, would be considered or deemed to be a cessation of use for the purposes of this determination. You could probably say something like that, which would give you the path you're talking about.
And let me just tell you, we're beginning to enter the 3rd stage of our EAR process. We did the evaluation and appraisal report, then we amended the comp plan consistent with the EAR. Now we're going to amend our zoning to make it consistent, all of our LDRs to make those consistent with the amended plan. And one of the things we've had on the table to do for a while is make some changes to the non-conforming chapter. And we will look into this, and when we come to you with the changes to the LDRs, we'll present you some alternatives. We'll work with the attorneys, and maybe we can put something in that does allow consideration of having needed licenses and how that affects a cessation of the nonconformity.
And you need to keep in mind that a determination that a nonconforming use has ceased, and therefore you cannot continue in that nonconforming use. Courts have sometimes held that to be a taking, if you're wrong. So you got to be careful here. On the other side of this spectrum that you're looking at is the possibility that you step over the line, it becomes a taking, and suddenly the county takes on liability for that.
You bet.
So it's a difficult question.
Thank you. Mr. Zimmerman had a question.
It seems to me that one of the fundamental problems of this case has a lot to do with the alleged code compliance issues and contamination and things like that, which I think any neighborhood would be concerned about. And so I guess the question I have for you, and this is piggybacking on to what Jen's said, is how much of a penalty can code compliance put on this type of business when we're trying to find some way to bring them either into compliance or to have them stop being a nuisance to their neighbors? And I'm just wondering, is code compliance enough? Shouldn't that? It seems to me that should be the recourse we have against them. But if it's nothing that anybody's afraid of, if it can't really eventually put them out of business, if they're just thumbing their nose at people over a very long period of time that's documented, I'm just saying, I'm not sure the course we're going down is the right one. It seems like it ought to be down the code compliance course, and it should be aggressive. And if it's documented over many, many years, then, hey, it shouldn't be in the land use area. It should be in the code compliance area. So what's the ultimate penalty for code compliance here?
Actually, we didn't do this for code compliance. We didn't do it for code compliance regarding the environmental issues, the pollution, the contamination. That isn't why we did it. We did it to just implement our non-conforming provisions. What this is, most of this property is zoned light industrial. Junkyards are not allowed in light industrial. The reason we have grandfathering, the reason we have non-conforming use provisions is that a use that was legal and appropriate when it was established should be allowed to remain as long, even when the zoning changes, as long as that use stays in business for a continuous period.
I understand, but it's obviously an aggravating factor. From the testimony I heard, it was clear to me that an aggravating factor was the allegation that this particular operator was noxious to some of the neighbors. I mean, that was alleged.
Right.
And so, to me, the code compliance issue was an aggravating factor in terms of this case being brought before us.
But that isn't why we brought it.
I'm not accusing you of that. I'm just saying from the testimony I heard, that sort of seemed to be a factor.
Oh, I think it was, a factor particularly in people looking at this, and outside people. We looked at it from the perspective, there were hundreds of cars there in 2005. In 2007, they were gone. This is a junkyard. How do you have a junkyard without junk cars? We just looked at it from that perspective, and the perspective that one of the reasons why you have non-conforming provisions is to eventually have uses in a district conforming. So eventually they should be phased out, and there are reasons for that. In this case, there's residential adjacent to this. And
but what's the ultimate cure in terms of code compliance? I guess that's my question. I mean, how heavy is the hammer of code compliance ultimately against a business owner who is non-responsive?
Well, I mean, the general process is our fines and liens against the property, typically $100 per day. For repeat violations, we up to $500. If it's a non-homestead property, since this is a business, there's an opportunity for the county to foreclose if it gets to that point, and if it's has priority of lien to do that. That's ultimately
that's a strong power.
The powers are substantial.
That's substantial.
Up to $500 a day, and it can then become a lien on the property. As Roland says, if it's non-homestead, you can foreclose it. In fact, the commission, 3 weeks ago, authorized me to go ahead and foreclose on the Vista Gardens property down there, and within a week we had the owner come in and hand us a check.
Right.
So it gets their attention.
When you're taking private property, that's a powerful force.
And let me tell you, this isn't just this isn't just code enforcement. The Environmental Control Board has a case against him, and DEP has some pretty significant sanctions. Actually, they had one of the sand mining operators in handcuffs when he was violating their rules. So their enforcement is real tough.
I know from my point of view, at our last meeting, I was struggling to get my head around this whole issue of continuous use or interruption of use. I was going through the packet that we had and trying to count months and trying to get my head around that. And at the end of the day, I don't think I would have been able to do that. So I'm glad we tabled it, although it didn't feel right at the time. I'm also glad that you have made the decision that you made, and I'm glad that you're pursuing this from other avenues that don't involve us. So I think it worked out.
Okay, any further planning matters?
I'll let you know, we still haven't got much development activity, so it looks like there could be some more meeting cancellations, except what we find is some cases just never go away.
And what about the concrete?
That's one that never goes away. And you may be seeing, I'm sure you're going to be seeing the ocean concrete item sometime in your next few meetings, because we are going to be sending out a letter tomorrow saying that the applicant has met all requirements for site plan approval. But we're going to say that site plan approval is still dependent upon a resolution of the vested rights issue that the applicant has raised and that the county is looking at. But there's no question, whichever way we go on a couple of different decisions, some party is going to appeal it. Mm-hmm. So, and the appeal will end up here.
That makes it easy.
Can I ask a favor?
Sure.
Can I ask a favor? I knew this last meeting, we got in the habit, particularly with very consequential meetings, of making sure, of saying who's going to be there so that we have a quorum. And we didn't do, I think the last couple we haven't really done that. Can we get back to,
You were being polled by...
Yeah, we were being polled, to go, we're making sure we have a quorum, that there's going to be enough people showing up.
We'll make sure you're called, but that's a good point. or emailed.
Yeah.
Has anyone got some meetings coming up that he or she can't make?
No, it depends on how far out this is.
Let's do it by email.
By email would be
Okay.
recommended.
We'll do it. And that's all I have.
Okay. Attorneys matters.
No matter.
Okay. Meeting's adjourned.